be seated. All right, this is case DCFM protection plaintiff versus defendant. Today we have Mr. on court with his counsel, Julie Cavanaugh-Bill. We have Ms. here. She's represented by counsel Richard Davies, who's appearing by real-time audio visual means. You can see and hear me okay, sir?
I can, Your Honor. Thank you for this allowing me to appear by Zoom. Thank you.
All right, we can see and hear you as well. This is Judge Kacin for Judicial District Court, Department 2 here in Elko, Nevada. We are here for a brief status hearing. And let's have a look here. This was set under an order entered August 28th, so pushing a month ago. We have a status hearing, and really this involves an order continuing ex parte relief involving the parties' minor children. There are three. There was most recently, it looks like, an ex parte motion for sole physical custody and child support filed by the defendant. That was filed August 21st. The court did grant ex parte relief on the 25th. 26th, the court held a hearing to determine whether that relief would continue as required by our local rules. That's to be within 10 days of the ex parte order being entered. So the court did hold that hearing. The court learned that the plaintiff had been engaging in supervised visitation with the two younger children the parties have at the local DCFS office, and said, look, we're going to continue ex parte relief, find out what happens with this investigation. In the meantime, the court did enter other orders for the parties to engage in some, or take some courses that are free, offered through the Elko Family Resource Center, and they're listed there in the order. So the court had also indicated that plaintiff's counsel had to file the substantiation or unsubstantiation letter, as the case may be, from DCFS as soon as it was received. So I don't believe we had a filing in that regard. So where are we with that, counsel?
Thank you, Judge. So I spoke with the division yesterday, and they apologized for the delay. Their state system has been down for several weeks, but she did tell me that they should have everything completed by next week.
Okay.
And I asked her for expedited delivery of that, so that I can get it to the court.
All right. I don't know if you looked into that. Is that news to you then, Mr. Davis?
It's not a surprise. My understanding was that there had been no information received at this point, and that's confirmed by Ms. Cavanaugh-Bill on that. So I don't have anything else to offer regarding that issue.
Okay. And then I also noted that the parties had filed the written reports of the mental health and substance use evaluations that the court had ordered. And I have reviewed those briefly. And I take it that each party's got a copy of the other, is that right?
Yes, sir.
Yes.
Okay. All right. Well, I know I was looking through this file just to kind of see where we've been. I mean, we have a couple of volumes now, and I wanted to see if maybe we could turn this hearing into something a little more than just a status hearing on where we are with the DCFS investigation. I would note the trial is set for December 18th of this year. You're aware of that, I'm sure, Mr. Davies?
I am. I certainly intend to be there, and I also know we have a hearing October 9th, which I absolutely intend to be there for as well.
Yeah, I was going to go there too. We do have a hearing on October 9th on a motion for return of separate property funds. That's how it's titled. That was filed early on in the litigation. I think Mr. Davies was not counsel when the trial was originally set by case management order in August. And it is just a one-day trial. I've seen that this litigation is becoming, word contentious. Do you think one day is going to be enough for this trial, or do we have to increase the amount of time for trial?
Well, I spoke to my client yesterday. She did indicate a possibility of other witnesses that we hadn't talked about before. So I'm kind of picking up on something that could be a concern that started in my mind. I started thinking, okay, I just kind of went down this path that you're going down right now too. I also referred also to Ms. Cavanaugh-Bill about that. If we want to make, I don't know if it's possible to do 2 days as well back to back, just to play it safe. Does that make sense? Or,
well,
I can't say.
What I would like is if the reason I brought it up, and I'll do this for jury trials too, just to check in status hearings, do we have enough time? Do we have too much time? Where are we at? So what I would like is if counsel could get together and make a real good, reasonable estimate about how much time we need for trial. This is still a fairly new case. I mean, this would, I believe, wrap up the case pretty quickly if we do have a trial in December. I anticipate keeping that trial date. If you feel like you need a little more time though, maybe you can let me know at the August 9th hearing.
That makes sense.
After discussing the matter.
I can, right after with enrollment now with CPS, we've got, I think, 3 or 4 evaluators or therapists involved. And then we would have 3 more witnesses. So right there, that's 7, and I'm not sure from Mr. Davies' side. So I think 2 days.
Okay. Well, if you're prepared to make that estimate now, I'll let my judicial assistant know ASAP. That is after this hearing. You think
That makes sense.
You think 2 days too, Mr. Davies?
I think it's prudent to carve out another day. I'm hoping maybe that we do it back to back, the 18th and the 19th, because I'll be there already. I don't know that, of course, that depends on what the court's calendar is, but
Sure.
that'd be good if we could do that.
Well, I'd like to accommodate counsel if I can. I also like to have all the evidence come in on back-to-back days if possible. Breaking up trials is, bench trials is not something I relish. I just think it's more effective use of my time, certainly, and not to mention yours, to just conduct the trial on back-to-back days so that we can, it's fresh in everyone's mind. You can have a closing statement if you'd like to. And then a lot of times, the court makes findings of fact, conclusions of law, and orders at the end of the trial. So anyway, yeah, I'll look in on that. That's December 18th. I just checked my old-fashioned calendar up here. Is a Thursday, and 19th, obviously Friday. We'll see if we can get that.
I'm not available on the 19th.
You're not available on the 19th. How about the 17th?
I'm not.
I may look at my calendar.
Well, counsel's already saying she's not available then.
Okay.
What about the 16th? And at least we're close in time on that same week. Then the next week, I'll warn you, is Christmas week, and a lot of people are gone that
That's a
week.
mess.
I have a hearing on the, if we want to shoot 2 days, I have a hearing at 9 a.m. on the 15th. It's a
Okay.
status hearing, but it should be too long, and then I am available on the 16th.
Well, the 15th is my regular law and motion day. I also run my adult drug court, and I'm a busy dude on those days, on those Mondays. I can shift around the law and motion calendar, but I losing those drug court days is generally, that's not acceptable. So how's the 16th then? Council is saying the 16th, Mr. Davies?
I've already got a couple things on the 16th, or I'm already seeing a conflict on the 16th, so I'm not sure what adding another conflict makes sense to get the other 2 off. I'd have to talk to my staff about that. the other attorney in my office, she's on maternity leave, so I think she's covering one of these. But I am in district court in Douglas County on the 16th in the morning, which would preclude me from being there on the 16th altogether. That I think can be moved, though. I think we can move that.
You think you can move Douglas County, you're saying?
I think I can, yeah, it's gonna put pressure on my staff a little bit, but, and that's it. That's also contingent on the court granting that, which I don't think I would, but.
Okay, well, the other option is we could try to maybe move it up or down a little bit to keep the 2 days back to back. I hate splitting those trials up. Especially.
I couldn't agree more.
Yeah, especially when we have I'm very understanding we have counsel practicing in Reno coming over here to litigate. If you can just come over once, obviously that's better than driving back and forth.
I appreciate that.
Times.
I can say the week before, I'm in a week-long trial, and I'm always gonna go off, but again, I could be not smart to calendar that. Unless we can all agree maybe to bump it out a little bit to January, if that makes sense to Ms. Cavanaugh-Bill, or if that's suitable in the court.
Yes, Your Honor, I actually have some availability the week of January 13th or the week of January 27th. I'm starting at Tuesdays, because I know your Mondays are lunch.
Okay, so the week of January, well, 13th is a Tuesday. I always start my weeks on Sundays, so January 11th, the week of January 11th,
I can do 13th and 14th, that works.
13th and 14th.
That works for me, Your Honor.
Okay,
Okay.
well, my law clerk's in the back. Can we check with our judicial assistant, see what's going on? Maybe you can shoot me a note over here. I didn't bring my computer out here, so she can just write me a note. That'd be great. 13th and 14th, you said, right?
Yes, Your Honor.
That would work for me.
Okay. And then everybody's good to go on October 9th, is that right?
Yes, Your Honor.
Correct, and I'll be there in person, yes, thank you.
Okay. And then that would be the hearing on the motion for return of separate property funds. And this is an evidentiary hearing, correct?
Yes, Your Honor.
That's my understanding, yes.
That's mine as well. That was originally set, I believe, in August, and then parties had stipulated to continue that. So, yeah, the court had entered a stipulated order, landed on October 9th, which is not terribly far away, and I think is also another opportunity to find out where we are with the DCFS investigation.
Your Honor.
And I had that calendar at 3 p.m., is that, we're all on the same page about that as well?
I'm looking at the old-fashioned file here.
That is what I have, 3 to 5.
Yeah,
Perfect.
I believe that's correct.
And Your Honor, if I may.
This,
I know that my client at least is willing to attempt some kind of mediation or settlement conference again. So I guess I could contact Mr. Davies and see if we can schedule that before trial. If this group is willing to do that as well.
okay, did you hear that, Mr. Davies?
I did, and let's, Julie, or Ms. Cavanaugh-Bill, maybe let's try to chat, either today or sometime this week.
That sounds good.
I know you reached out, we chatted a little bit, just to get to know each other, but, I don't think it's ever bad to try to talk and communicate.
All right, I do have an evidentiary hearing on the 14th, and I'll jump back to the mediation piece. I do have an evidentiary hearing on the 14th of January and the 15th. It's in a post-conviction matter. Criminal case, obviously. But in that case, there's a motion to dismiss some of the claims. And it's possible if the court dismisses some of the claims, this hearing's not going to be as long as the 14th and the 15th. So I'm willing to schedule you in on January 13th and 14th, okay? And see about, if I don't dismiss claims in that other case, just flopping that over into the 16th, which I think is, take a calendar again, is a Friday.
That would be,
Which means I could do that, so I'm willing to give you the 13th and the 14th.
thank you, Judge.
Perfect, I'm putting on my calendar now.
All right, everybody, sure, you're available then.
Yes, sure.
That works.
You need to call your assistants, check your phones. No?
That's far enough out where I know I'm safe.
All right, so January 13th and 14th, we're continued, I'll enter an order continuing the trial. As far as I'm concerned, unless there's some stipulation for something otherwise, the deadlines that I laid out in my case management order entered August 12th, those would remain. We're just continuing the trial and now making it 2 days instead of 1. And so, you know, we do have a motion hearing on the 9th of October. I'll also set a new status hearing regarding this issue of the DCFS investigation, update for that to occur then. And then, let's see. As far as mediation is concerned, you were mediating with Gabrielle Carr previously, and I was looking through the file, as I said, and it looks like the parties had stipulated May 14th to go to mediation. May 27th, the court said, or got a memo. This is how Gabby tends to do this. She filed a memo, copied you all. Memo for that there was an agreement basically to adjust maybe some visitation. Looks like it's centered around child custody issues. I don't know if they ever attempted to mediate anything else. Is your client saying he wants to try to mediate the whole ball of wax or
I think he's willing to do so, Your Honor.
all issues? Okay. Mr. Davies, is that what your client is willing to do?
I'd have to talk about that. I know we talked about that before, and there may be some skepticism about we're able to make an agreement in the past, what makes me be able to do one in the future or now in the present. But it's always my opinion that it's worth going to the table and see if we can take some issues off the table and maybe refine our trial to a smaller set of issues instead of everything.
Okay.
So I'll talk to my client. I guess that's the short answer.
Okay, then we can have an update on that on the 9th as well then.
Perfect. Yeah.
And, yeah, in the past, and I do sing the praises of Ms. Carr because even if she's unable to help the parties arrive at an agreement to resolve all issues in this divorce, she's often able to help the parties reach agreement on some, and even frame the issues for trial really well. She'll draft. I don't know how familiar you are with her because I don't know how much she's working in other locations where you practice, Mr. Davies, but we commonly, the judges here in the 4th Judicial District Court commonly go to her, Ms. Carr, and she's able to, come up with, she's able to draft orders that are very specific about what's been resolved and what the parties have agreed on. The court can make those orders, and then she's also good at framing the issues that the parties agree should go to trial. When lawyers are involved, she has, I believe, the lawyers sign off too on any agreement. So mediations are typically done with just the parties, but I think she's open to having lawyers involved too, and she's willing to do them remotely. So we'll check in.
We'll talk about October 9th. Okay, yeah, thank you very much, Judge. I appreciate that.
Okay. All right, and have the parties done any of the classes that the court had ordered? Okay. And then Ms.
I'm pleased to see she has started counseling with Cheyenne at Quest. My understanding is, this sounds like your admonishment from our last hearing just resonated. October 2nd, both parties are going to start a co-parenting intake at Life Quest. Hopefully they'll sit in the same room and learn how to co-parent together. And then Janelle Anderson is doing family therapy, I think for the whole family too. So the short answer is yes. My client has 3 or 4 different family appointments with 3 different various members of the family, and I'm of the opinion that counseling can never be bad, right? It's never hurt.
Okay.
I understood your question, Your Honor, to be the actual courses.
Yeah.
You had ordered to family resources.
And I appreciate that response. I was talking about the classes.
I apologize.
Okay. Do you know if she's started those or?
And I'm sorry, we spoke yesterday, I totally forgot to ask about that. So I'd have to ask, did we start the classes that were recommended last time?
Classes.
No, these are the, let me find the list again. These were classes that I've found, when people report to me, they've found fruitful in the past. Active parenting, first 5 years, active parenting now. You don't have to do them all at the same time. These are just a listing of courses. Cooperative parenting and divorce, academic success through parental involvement.
No, I have not done those classes like that.
Okay.
And Your Honor, frankly, I think I missed that in my notes last time at our meeting. I was kind of focused on the counseling, that we got that started, but we will start the classes as well. And I apologize, one more time, we start those at?
Family Resource Center. This is laid out in the court's order. The continuing ex parte relief, August 28th. So you can just review that. It'll be in there. Yeah, I do try not to overload people. I'm not saying you have to do all this at the same time. I guess the order, I see it in here. I said forthwith register for and complete these courses. I mean, really what I'm talking about is, do one at a time, do what you can as you go along. I know there's a lot on your plate, so I certainly don't want to overload, but I would like the parties to do those. I think they'll find it helpful. Okay, so Janelle Anderson, at LifeQuest, she's the director. She has done a lot of, she's been really helpful for a couple of our participants in specialty courts navigating family issues too, which has become a big piece of our specialty courts for obvious reasons, I think. So if these parties could get in there and work with her, I think that would be dynamite. Counseling in the appropriate doses with good counselor, good therapist, client relationships, that works. Generally, I think helpful. So I applaud the parties in going forward with that. And I see that they're taking seriously, I think, what was covered in the reports of the mental health and substance use evaluations that way. Okay. And then, do we have anything else for today then? Okay. Anything else?
That's pretty thorough, Judge. I think that's comprehensive, Judge. Thank you.
All right. So again, I'll enter the order resetting the trial for the 13th and 14th of January 2026. We'll still see you here on the 9th of October for your hearing on the motion for return of separate property funds. At the end of that hearing, maybe at the beginning, we'll go ahead and discuss where we are with the DCFS investigation. Previous orders will remain in effect, we can finally dispose of that. Motion was filed early on in the litigation, so. All right, if there's nothing else, then we'll have a good day. We're waited 30 minutes, court's in recess for this one.